Convenient. What is the National Security Agency or NSA up to? The National Security Agency or NSA, an intelligence agency of the U.S. government, is responsible for the making and breaking of codes used to encrypt sensitive communication and for the interception of signals on behalf of the federal government. The NSA established a comprehensive telecommunications network capable of monitoring billions of emails and phone calls, whether they originate within the United States or overseas. The Advanced Encryption Standard (AES) algorithm is the current state of the art standard for encrypting top-secret communication. According to experts, it would take approximately 12 billion years to break the code via a trial and error brute force attack using today's supercomputers. Privacy and protection and the law. The use of information technology in both government and business requires balancing the needs of those who use the information that is collected against the right and desires of the people whose information being used. However, many people object to the data collection policies of government and business on the grounds that they strip individuals of the power to control their own personal information. First, it's important to gain a historical perspective, the right to the privacy. During the database on the adoption of the United States Constitution, some of the drafters expressed concern that a powerful federal government would intrude on the privacy of individual citizens. After the Constitution went into effect in 1979, several amendments were proposed that would spell out additional rights of individuals. 10 of these proposed amendments were ultimately ratified and became known as the Bill of Rights. Information privacy. Combination of communication privacy, the ability to communicate with others without the communication being monitored by other persons or organizations, and data privacy, the ability to limit exercise a substantial degree of control over the data and its use. The following sections cover concepts and principles related to information privacy, beginning with a summary of the most significant privacy laws, their application, and related court rulings. Privacy laws, application, and court ruling. The section outlines a number of legislative acts that affect a person's privacy, notes that most of these actions address invasion of privacy by the government, legislation that protects people from data privacy abuses by corporation is almost non-existent. Financial data. Individuals must reveal much their personal financial data in order to take advantage of the wide range of financial products and services available, including credit cards, checking and saving account, loans, payroll, direct deposit, and brokerage account. The Fair Credit Reporting Act regulates the operation of credit reporting bureaus, including how they collect, store, and use information. The Right of Financial Privacy Act protects the records of financial institution customers from unauthorized security by the federal government. The Gramm-Leach-Bliley Act, or GLBA, also known as the Financial Services Moderation Act of 1999, was a bank deregulation law that repealed a Depression-era law known as Glass-Steagall. Key privacy and anonymity issues. Data breaches. An alarming number of identified Theft incidents can be traced back to the data breaches involving large database of personal information. Electronic discovery. Discovery is part of the perennial phase of lawsuit in which each party can obtain evidence from the other party by various means including requests for the production of documents. Consumer profiling. Companies openly collect personal information about users when they register at website, complete surveys, fill out forms, or enter contests online. Workplace monitoring. Plenty of the data exists to support the conclusion that many waste large portions of their work time doing non-work related activities. Advanced surveillance technology. Advocates of advanced surveillance technology argue that people have no legitimate expectation of privacy in public place and thus forth.
Outsourcing. Outsourcing is another approach to meeting staffing needs. Outsourcing is a long-term business arrangement in which a company contracts for services with an outside organization that has expertise in providing a specific function. A company may contract with an organization to provide services such as operating a data center, supporting a telecommunication network, or staffing a computer help desk. Example: let's say a company decides to outsource its customer support services to a third-party call center located in another country. Instead of handling customer inquiries and issues in-house, the company contracts with the call center to manage all incoming calls, emails, and chats from customers. This allows the company to focus on its core business activity while reducing costs and potentially gaining access to specialized expertise from the outsourcing partner. Offshore outsourcing. Offshore outsourcing is a form of outsourcing in which the services are provided by an organization whose employees are in foreign country. Any work done at relatively high cost in the United States may become a candidate for offshore outsourcing, not just skilled work. However, professionals in particular can do much of their work anywhere on a company premises or thousands of miles away in a foreign country. In addition, companies can reap large financial benefits by reducing labor costs through offshore outsourcing. An example of offshore outsourcing is when a software development company based in the United States hires a team of programmers located in India to work on a project remote. The company sends the project requirements and specifications to the offshore team, which then develop the software according to the company needs. Offshore outsourcing often choosing to take advantage of lower labor costs in other countries while accessing skilled talent. Pros and cons of offshore outsourcing. Wage that an American worker might consider low represent an excellent salary in many other parts of the world, and some companies feel they would be foolish not to exploit such an opportunity. Why pay a US workers a six-figure salary? The reason when they can use offshore outsourcing to hire pre-India-based workers for the same cost. However, this attitude might represent a short-term point of view. Offshore demand is driving up salaries in India by roughly 15% per year. Because of this, Indian offshore suppliers have begun to charge more for their services. Example: this is the list of examples of pros: cost efficiency, access to specialized expertise, scalability, and time zone advantage. Cons: communication challenges, quality control issues, data security risk, and dependency on external providers. Strategies for successful offshore outsourcing. Successful projects require day-to-day interaction between software development and business teams, so it's essential for the hiring company to take a hands-on approach to project management. Companies cannot afford to outsource responsibility and accountability. Example: through vendor selection, clear communication channels, detailed contractual agreements, risk management, cultural sensitivity and training, quality assurance, and relationship building. By incorporating these strategies, businesses can enhance the success of their offshore outsourcing initiatives while minimizing risk and maximizing benefits. Whistleblowing. Like the subject of contingent workers, whistleblowing is a significant topic in any discussion of ethics in it. Both issues raise ethical questions and have social economic implications. How these issues are addressed can have a long-lasting impact not only on the people and employers involved but also on the entire IT industry. Example: imagine you work for a pharmaceutical company and discover that some executives are knowingly hiding safety data about a newly developed drug to rush it to market. You're concerned about potential harm to patients despite the risk to your job and reputation. You gather evidence and report the misconduct to the appropriate authorities or regulatory bodies. This act of whistleblowing exposes the wrongdoing, protects public safety, and ultimately leads to investigation and corrective actions within the company. Protection for whistleblowers. Whistleblowers protection laws allow employees to alert the proper authorities to employer actions that are unethical, illegal, or unsafe, or that violate specific public policies. Unfortunately, no comprehensive federal law protects all whistleblowers from retaliatory acts. Instead, numerous laws protect a certain class of specific whistleblowing acts in various industries. Example: in many countries, laws are in place to protect whistleblowers from retaliation or unfair treatment by their employers. For instance, imagine you work for a government agency and uncover instances of corruption. You report this wrongdoing to the relevant authorities invoking whistleblowers protection laws. As a result, you're shielded from termination, demotion, or harassment in the workplace. These protections encourage transparency, accountability, and the reporting of misconduct without fear of reprisal. Whistleblowing protection for private sector workers. Under state law, an employee could traditionally be terminated for no reason or no reason in the absence of an employment contract. However, many states have created laws that prevent workers from being fired because of an employee's participation in protective activities. One such activity is the filing of acquitam lawsuit under the provisions of the False Claims Act. States that recognize the public benefit of such cases offer protection of whistleblowers. For example, whistleblowers may be able to file claims against their employees for retaliatory termination and may be entitled to a jury trial. If successful, they may receive punitive damage awards. Dealing with a whistleblowing situation. Each potential whistleblowing case involves different circumstances, issues, and personalities. Two working together in the same company may have different value and concerns that cause them to react in different ways to a particular situation, and both reactions might be ethical. It is impossible to outline a defined step-by-step procedure of how to behave in a whistleblowing situation. This section provides a general sequence of events and highlights key issues that a potential whistleblower should consider. Assess the seriousness of the situation. Before considering whistleblowing, a person should have specific knowledge that his or her company or a coworker is acting unethically and that the action represents a serious threat to the public interest. Begin documentation. An employee who identifies an illegal or unethical practice should begin to compile adequate documentation to establish wrongdoing. Attempt to address the situation internally. An employee should next attempt to address the problem internally by providing a written summary to the appropriate managers. Ideally, the employee can expose the problem, deal with it from inside the organization. Consider escalating the situation within the company. The employee's initial attempts to deal with the situation internally may be unsuccessful at this point. The employee may rationalize that he or she has done all that is required by raising the issue. Assess the implications of becoming a whistleblower. Whistleblowers feel they have made a strong attempt to resolve the problem internally without results. They must stop and fully assess whether they are prepared to go forward and blow the whistle on the company. Use experience, resources to develop an action plan. A whistleblower should consult with competent legal counsel who has experience in whistleblowing cases. He or she will determine which statutes and law apply depending on the agency, the employer, and the state involved, and on the nature of the case. Execute the action plan. A whistleblower who chooses to pursue a matter legally should do do so based on the research and guidance of legal counsel. If the whistleblowers want to remain unknown, the safest course of action is to leak information anonymously to the press. Live with the consequences. Whistleblowers must be on guard against retaliation, such as being discredited by coworkers, threatened, or set up. For example, management may attempt to have the whistleblowers transferred, demoted, or fired for breaking some minor rule, such as arriving late to work or leaving early.
Hello everyone, I'm Jarlyn Manuel and I'm going to report about the introduction to contingent workers. So first, what is contingent workers? Contingent worker is a worker who is hired on a temporary or fixed-term contract basis to provide specific services for a specific project or period of time. So, types of contingent workers. Types of contingent workers includes independent contractors, temporary workers, on-call laborers, and contract firm workers. For example, they are the independent contractors, the freelancers, the temps, and service labor working either on-site or remotely. Second is when to use contingent IT workers. Situations where firms benefit from employing contingent IT workers. Fluctuating technical staffing needs. Firms utilize contingent IT workers for pronounced fluctuations in technical staffing requirements. Second is organizational restructuring projects. Contingent IT workers are hired as consultants for organizational restructuring initiatives. Third is the product development teams. Contingent IT workers contribute as technical expert in product development teams. And for the fourth one is the short-term projects. Contingent IT workers are employed for short-term projects like new information systems installation. So, obtaining contingent workers, exploring various methods to source contingent workers. Employee leasing organizations. Companies can transfer part or all of their workforce to leasing firms, which handle HR activities and costs, providing benefits to employees, and also the temporary staffing firms. Here, organizations can partner with temporary staffing firm to recruit, to train, to assign seekers across various skills level for short-term projects. And last is the consulting firms. Here naman is the engaging to consulting firms allow access to a diverse talent pool with specialized skills and expertise for defined project engagements. So next is the advantages of using contingent workers. So here we can see the benefits of organizations gain from hiring contingent workers. First, it is cost savings. Second is specialized skills. Third is the flexibility in workforce. And fourth one is the quick response to market changes. When we say the cost savings, it is the organizations save on benefits costs by not providing insurance, paid time off, and retirement contribution. Second is when we say specialized skills, here naman is the contingent workers bring specialized skills without the need for long-term commitments, saving on training costs for specialists. And when we say naman the flexibility in workforce, this is the firms can easily adjust workforce size to meet business needs and release contingent workers when not required. And for the last one, the quick response to market changes. Here, when we say the quick response to market changes, it is the organizations can respond quickly to changing market conditions by utilizing contingent workers with specific skills. Next one is the disadvantage of using contingent workers. It is the challenges and downsides associated with employing contingent workers. The first disadvantage is the low company commitment. It is the contingent workers may lack a strong connection to the company they are working for, leading to low commitment levels. Second is the knowledge transfer to competitors. Here is the contingent workers may acquire valuable skills and insights during their tenure, which can be taken to competitors about project completion. Third one is the high turnover rates. Dito naman is the utilization of contingent workers can result in a high turnover rate due to the temporary nature of their employment. And last but not the least disadvantage of using contingent workers is the ethical and legal issues. Here, employing contingent workers can raise ethical and legal concerns, impacting areas such as payroll taxes, benefits, and compliance with regulations. So let's move on to the deciding when to use contingent workers. It is a factor to consider when employing contingent workers. Ito yung mga dapat natin i-consider kapag kailangan natin or nag-hire tayo ng mga contingent workers. First one is the unique skills versus in-house talent. Here, organizations should evaluate the necessity of unique skills for temporary projects against investing in developing internal talent. Second, we must consider the risk of proprietary information. When we say proprietary information, it is to consider the potential risk of sharing sensitive proprietary information with contingent workers during project engagements. So next is the misqualification consequences. Here is the misclassifying workers can lead to lawsuits and financial penalties. So that's one of the consequences. Second is the Microsoft settlement. Microsoft faced a $97 million settlement for misclassifying firm attempts. So, yung dalawang yan is the legal and ethical consideration. It is the implication of misclassifying workers. So, now we are going to talk about the H-1B workers in the IT sector. Here are the role and impact of H-1B visa workers in the IT industry. First is the specialty occupations. This is the H-1B visas granted for roles requiring specific bachelor's degrees or equivalent experience. Ganyan naman na ngayon. Like, we need talaga ng degree to be employed or para matanggap sa trabaho. And second is the skill shortages. Employers utilize H-1B workers to address critical skill gaps and acquire specialized expertise. Third is the prevailing wage requirement. When we say prevailing wage requirement, it is the employers mandated to pay H-1B workers the prevailing wage for the role performed. And lastly is the potential permanent residency. Here is the visa holders can seek permanent residency with employer sponsorship. Pag sinabi kasi natin H-1B, it is a program that allows companies and other employers in the United States to temporarily employ foreign workers in occupations that require the theoretical and practical application of a body of highly specialized knowledge and bachelor's degree or higher in the specific specialty or its equivalent. So here, makikita natin is the manager checklist for contingent workers. It is a guidelines for effective utilization of contingent workers. First one is the review employee definition. Second is the finite assignments. Third is the specific contracts. Fourth is to avoid direct supervision. And lastly is the leasing firm benefits. So here, when we say the review employee definitions, we ensure that company policies do not entitle contingent workers to benefits by carefully reviewing employee definitions. Siyempre, bago tayo mag-hire, kailangan muna nating makilala yung hina-hire natin. Second is definite assignments. So here, we assign a contingent workers finite tasks with breaks in between to avoid extended usage. So third is the specific contracts. Company use contracts that is explicitly designate workers as a contingent workers to clarify their employment status. Sa lahat naman yan, kaya need talaga ng contracts, kaya na lang din ng mga nag-abroad. Avoid direct supervision. So here, we communicate job requirements through the contingent workers manager rather than directly supervising them. And lastly, the leasing firms benefits. So here, utilize leasing firms that provide benefits. Sila yung nag-handle ng payroll taxes and offer required insurance for contingent workers. Utilize contingent workers effectively. Kapag nag-utilize tayo ng contingent workers effectively, we empower your workforce with contingent talent. So, that's all. Thank you for watching.